everyone. I'm Leslie Rohde for AskTheLawyers.com, and welcome to another episode of Ask the Lawyers. Today's topic, it's a big one, medical malpractice. And we are happy that attorney Frank Cristiano is with us to answer some of our questions. He's with Cristiano Law, LLC in Denver. Welcome, Frank.
Thank you. Glad to be here.
Well, let's just first start with a definition of medical malpractice. What is it? What is a legally actionable case, a claim?
Well, I guess when I answer that question typically, and maybe I discuss with the jury a little bit from time to time, I always like to mention that it's a misnomer because the standard, it's really not about malpractice. The term malpractice has to do with the origins of the concept, which began in the early part of the 19th century, or the 20th century, I should say. Where it had to do with somebody who was, essentially practicing quackery. It has evolved over a period of time through the 20th century so that it embraced the concept of negligence. So it's not so much having to prove that the doctor was a bad doctor, but that the doctor was negligent. The definition that the jury gets is that the doctor did something that a reasonably careful and competent doctor would not have done in the same or similar circumstances, or didn't do something that a reasonably careful and competent physician would have done under the same circumstances. So it's a negligent concept, and it has to do with standards of care practiced in the industry as testified to by other physicians in the area. It needs medical support and expert medical testimony support to be sustained in the court. So it's a negligent concept, whether or not the doctor was acting reasonably and competently in the circumstances, and if he wasn't, whether or not he or she caused you injury.
So am I to understand then that a medical malpractice claim, there's definitely something different between that and just a bad outcome of some procedure?
Yeah, oftentimes I get calls from people and they've had a horrible outcome from surgery or whatnot. But just the mere fact that they've had a bad outcome doesn't equate to a conclusion that there was malpractice or medical negligence involved. So in America, the jury is instructed at the request of the defendant during trials that a bad outcome in and of itself does not equate to a showing of demonstration of negligence. There's oftentimes, situations in medical practice where there's a bad outcome, and you can't really prove whether or not that bad outcome was created by negligence by the physician. And if that's the situation, you can't win the case. So bad outcome in and of itself is not proof of negligence. It suggests that there might have been negligence because medical procedures are not supposed to encounter those types of complications.
I would imagine you've probably received calls from people too who have signed those medical waivers before a surgery or some sort of medical procedure at all. I know I've had to sign them before. I've had procedures done before. How do those waivers affect a potential malpractice case?
Well, there's a concept called informed consent, and before an operation takes place, which is probably the best, or any kind of procedure takes place that bears risk with it, the patient has to be advised by the physician as a standard of care as to what the doctor's assessment is of the patient's condition, what the doctor is assessing or what is recommending in terms of treatment for the condition. And most importantly, what the risks of the procedure, what the acceptable risks of the procedure are. So the doctor has to say, even if I exercise good care with regard to the surgery, these are the negative consequences that can happen to you. And you have a choice. And then the doctor not only has to tell you that, but tell you what your choices are. Sometimes it's a good choice. Sometimes it's a choice of there's no choice at all. We don't do the surgery and you're going to die or something like that. But they have to tell you all of those things. Now, so one of those things is they have to tell you what the expected risks of the procedure are, and it has to be in writing, and it has to be signed, and it has to be signed before the surgery is authorized by the hospital. So that informed consent advisement form will always be in your hospital chart. And if you've got something, if you have a consequence from a surgery that's fairly well described as one of the risks of the procedures, then you've got a situation where the lawyer is probably going to look at that and say, gee, this may very well have occurred as a result of the doctor not practicing reasonable care during the course of the operation, but it's just a real tough thing to overcome in terms of winning this case, so I'd probably rather not take the case. So the bottom line is, if you have to go over that informed consent advisement form and look at it and see if the doctor has described the type of risks that were encountered that the patient is now complaining about in terms of a potential malpractice suit. And if it's on that list, then essentially it's probably not going to be a winnable case.
Maybe a challenge, yeah. So what happens when someone calls you? If someone calls you and they don't know whether they have a medical malpractice case or not, but what is the process that you will go through as an attorney to evaluate that claim and decide whether to take the case?
Well, I've got, I think that what happens with the lawyer is the lawyer has a certain amount of understanding of the, underlying medicine, and he or she has a fairly good sense of whether or not what they're talking about could be a product of medical negligence or medical malpractice. So you start from there. But the big, and if you get a sense that, that there's a good possibility here that there's sort of a black or white line that was crossed by the physician in terms of medical negligence, and that's what caused the problem, then the lawyer may get more and more interested as he or she goes along. And then he will contact a physician and probably pay for the physician's services to review the medical records and get a determination as to whether or not there exists, some sort of probable cause that there was medical negligence committed, and that medical negligence caused injury. But before the lawyer gets to that point, the lawyer has to make a very sort of tough and hard assessment in terms of whether or not it constitutes a good economic decision for the lawyer to take the case. And that's where most people get disappointed, and that's where most of the times the cases are rejected by the attorney, because they are very, very expensive to move forward on. They involve a tremendous amount of expense. They involve a sort of a pretty high likelihood of having to go to trial, much greater than the ordinary personal injury cases. And doctors are oftentimes very successful at convincing juries that they didn't do anything wrong, even if they very well do so, or had done something wrong. So they're high risk cases. And then there's this thing about, so the lawyer has to look at what risk is the client asking me to take? And is it worth it? Does it make economic sense for me to take this case? And you have to sort of assess what the potential cost you would have to advance to the client. So the client comes to you and say, will you make me a loan? Typically, that constitutes, the amount of cost that the lawyer will have to pay out of his or her pocket to advance the case through a trial. And it may be likely a non-recourse type of loan, although that has to be decided between the attorney and the client. But, and then I've got to put all sorts of time into this thing. I'm going to there's a real good possibility that we might have to go to trial. And then we got to decide whether or not it makes economic sense for, me to do that. And if the numbers don't add up to, likely into, well, there's exceptions. It depends on how obvious the malpractice is. But the numbers have to be fairly high to justify a lawyer saying, okay, I'll take the risk and I'll put in all this time and money into this case. And I really believe in it. And I'm planning right now to take it as far as I need to go, and I'll take it through a trial if need be. And I've tried plenty of these cases. So, but it has to make economic sense. And then there's this big thing, and I don't know if you're going to ask me about this, but I don't want to preempt the interview. But there's this big thing about, in Colorado, there's restrictions in terms of recovery. And the big restriction that's existed since 1988 is that there's a cap with regard to recovery for non-economic loss. So the client can come in and say, my life has been entirely ruined by the effects of this malpractice. I mean, I can't do this, I can't do that. I'm in constant pain. I'm never going to be the same, and I really want to be compensated for that. And the lawyer looks at it and says, I entirely understand that, but, and I sympathize with it. I'm a plaintiff's attorney. I'm in this business because I have compassion for people. But on the other hand, I have to look at the economic reality, and the economic reality is greatly affected by the cap.
Yeah.
So the cap in the state of Colorado for non-economic loss is $300,000. And, that may sound like, not an insignificant amount of money, but when you're looking at a case that takes, $100,000 to $150,000 to take through a trial, or $200,000 to take through a trial, and the lawyers, you got to get reimbursed for all those costs if you win, and there's all these huge risks. If it's just economic loss, it better be a real obvious case before the lawyer takes the case. If it only involves non-economic loss. So you look at the economic loss, and the economic loss can come in various forms. It can come in a career a career that's going fine that gets ruined by the consequences of medical malpractice. So the person's been entirely disabled from engaging in this career where he was making $150,000 a year, and he has a 20 to 25 year life expectancy in terms of continuing on in this career, and that's been eliminated. That can add up to a lot of money. You look at also medical care costs, not only in the past but in the future. And a big thing is you look at home health care costs, and particularly when you've got these profoundly injured infants or children, and they've suffered severe injury and disability. What's it going to take to take care of this kid for the rest of their life? That can add up to a lot of money. So the lawyer looks at it, has to look at it first of all from a medical standpoint. Whether or not he thinks that there has been medical negligence involved, and whether or not that medical negligence has caused injury. And he has to, of course, and be able to bond with the client, and he has to make that assessment. But then, very importantly, he or she has to make an economic assessment and determine that the likely recovery is going to add up to sufficient, that's recoverable, that isn't included by the caps, is going to add up sufficiently so that the case is a case that he or she can take on a contingent fee basis.
Hearing you talk,
those are all the considerations you take into, and I think the big disappointment oftentimes is when I have to explain to people over and over again of this horrible cap that we got in the state of Colorado, $300,000, and how that affects them. And it's not that I'm not listening to them. It's not that I don't sympathize with the horrible nature of their injuries, and I'd really like to help them, but in the real world, because of these caps, I can't. And that's that. So. And there's a governmental immunity issue too, and I'm trying not to preempt your questions, but that adds into it as well.
Yeah, let's talk about that Governmental Immunity Act. I mean, you're there in Denver, and this Colorado Governmental Immunity Act. Tell everybody what that is there and how that does affect any claim against a governmental employee or an entity there.
Well, there's this concept called sovereign immunity. That you can't basically sue the king for anything, and that's carried over because we've embraced the common law, and so that concept is carried over from ancient times to present, that you can't sue the government for any torts. There's exceptions when there's a statute involved. So if it's a civil rights claim, that's a federal statute, and you can sue pursuant to the Civil Rights Act. But in Colorado, you start out with the proposition that individuals are exempt, who are governmental employees or governmental entities are exempt from tort liability. So, however, there is a Colorado Governmental Immunity Act that states exceptions to the rule. So the state has the authority to make exceptions to that rule. And there is an exception with regard to medical malpractice claims or hospital liability claims. But the important part of that, however, is that it's capped as well. So I think presently there's a $387,000 cap for a claim against a governmental employee or governmental entity. And a lot of these doctors that are particularly, practicing with the University of Colorado are covered. So now you look at that and you say, do I really want to take a case against a governmental employee because of that cap, which is sort of another layer that has to be taken into account by the lawyer before he takes the case. And that's a real tough case. The other thing is that, if you have a governmental immunity case, you have to give them written notice within 182 days of the claim, or the claim's gone. And sometimes people come in after the 182 days and you can't say anything other than, probably the claim, you don't have a claim because you didn't give them written notice within 182 days. So that's a problem as well.
A lot that we've talked about here and the different procedures, the process you go through, but I can imagine the bottom line here is when you get one of these cases, this has to be something that really affects you. As someone, you said, the reason you got in the law, these families have been affected. If it's a child, if it's anybody in the family, it affects the entire family when they're dealing with something. You want to talk to us a little bit about the satisfaction you get in helping people through these cases, or even give us maybe an example of something that you've been through with a client?
Well, I think that if you're a good plaintiff's lawyer, and I think I'm a good plaintiff's lawyer, and I've been doing this for a long time, you have to have a big heart. And you have to be able to connect with people, and you have to be able to love your clients, and you have to be able to love the cause that you're bringing forward for your clients, and you absolutely need that in a medical malpractice case. And the other thing, of course, has to make economic sense. That's the one sort of pragmatic decision that you make. But if you put all that stuff together and you become the champion of a client that you love, and you love the cause that you're bringing forward, it's an exceptionally satisfying experience. It's what many lawyers become lawyers for, and it's kind of it's the epitome of the achievement of a lawyer to take that kind of case and then be successful with it. Yeah. And you're not always entirely 100% successful. Sometimes you feel that you've gotten over a level where you do feel like you've really made a difference in these people's life, and you've helped them overcome a very, very sort of horrible injury or set of injuries that you've helped with, at least from an economic standpoint. And not only that, but they get the sense that you've listened to them and you understand them, and you truly do care. And all that really matters. So it's been a. I mean, I can go over cases with you, but I don't particularly have enough time. But that's the situation you want, and they do exist. I mean, I'm not. I've talked about all these reservations about taking medical malpractice cases, but there's a number of right medical malpractice cases that can be taken, even with restrictions that are involved. And if you do that and you pursue it, and you, particularly if you take it through a trial or close to a trial and get a reasonable resolution, then you feel real good about yourself as a person and an attorney.
I can imagine, Frank, that would be very satisfying. Thank you for sharing that with us, and then all of the other information that you've given our viewers today. We appreciate your time.
You're very welcome. Happy to be here.
All right, that was Frank Cristiano of Cristiano Law, LLC in Denver. We want to thank you for watching today, and don't forget to subscribe to our YouTube channel, Ask the Lawyers, so you won't miss another episode of Ask the Lawyers. I'm Leslie Rohde for AskTheLawyers.com, where you can choose a lawyer, let lawyers choose.